the concern that we're going to be discussing on this panel today is that trade agreements under negotiation could function to further entrench and expand the ability of the tech industry to cut off the opportunity to make these kinds of interventions. So just to take a step back, international trade law impacts the cross-border exchange of products and services, and it shapes as well how those products and services can be regulated by host government. So, you know, the US might sign a trade law and then be constrained in the scope of what it can enact at the national level. And not following these rules can have punitive consequences. Countries can be sued. There are sanctions that can be imposed until their domestic policies are removed or changed. So what brings us here today is that some of the trade policies that are currently being negotiated, namely the Indo-Pacific Economic Framework, would have direct impacts on the ability to do fairness and accountability work. And so Arthur and Lori have gathered together a really excellent panel of experts to educate us on what's happening in this space. So with that, I will turn it over to Lori. Are you our first panelist?
Good morning, everyone. Thank you for coming to this panel. I want to thank Arthur with Trade Justice Education Fund, who actually organized us, and all the co-panelists for joining. My name is Lori Wallach, and I'm the director of a group called Rethink Trade, and I'm a recovering trade attorney. And so here I am amongst all you technologists. I'm going to promise not to be dreadful. And if you want the details of what I'm going to talk about, because when a lot of people run through this the first time, they're kind of shocked. It's hard to believe this is what's really going on. It's a form of international policy preemption most people are not aware of. So I put the legal language in my slides. And the reason I put my email there is if you email me, I will send you the slides because I'm going to zoom through them, because a lot of people, I'm not going to walk you through trade agreement language fear math. You'll be walking me through math. But the reality is that this is here. It sounds so crazy you can't believe it. And so I put the language so you can see it's real and I'm not exaggerating. So please put down my email if you want the details. And the bottom line of this whole thing is this digital trade business is mainly not about trade, which is a lot of what's in today's trade agreements is not. So today's trade agreements are talking non-tariff rules that have to do with what you can do behind the borders regulation on stuff that is not what you would think about trade, right? Trade is products crossing borders. And then like what the border taxes, the tariff, that's what you think of when you think of trade. But that's not what these agreements are like. So like the World Trade Organization has an agreement that's like the anti-free trade. It sets up monopoly patent periods and extends them. And there are other agreements there that, like what you would imagine is not the trade agreement, regulates basically what governments can do at home. And this is the very brief history of the hijacking of trade agreements. After World War II, there were a bunch of international institutions to stabilize the global economy. The Bretton Woods institution, GATT, was the actual trade agreement. And then what has happened is that kind of got hijacked by a variety of corporate interests. I'm going to explain why. And we now have all these other things attached to the to a thing called the WTO, which replaced that GATT. GATT was literally only covered things you could profit or put. If it didn't cover a product, not covered in the trade agreements. Now you suddenly have rules on the service sector, intellectual property, food standards, procurement, all the stuff that should not have anything to do with trade. And this started really in the Reagan era, sort of mid-'80s, but culminated in the creation of a thing called the NAFTA and the WTO, and for all of our European friends, your EPAs, which are called Economic Partnership Agreements. And these are basically very nice names for agreements that you could otherwise call sort of hyper-globalization Trojan horses. So it's branded as free trade. And like anyone who went to college was told if you're not for free trade, you're an idiot. But in fact, what's in these rules does not have like a passing semblance of free trade, as in like Adam Smith gave a cover rolling in graves to see what is now being sold under their brand. The way it works as an international preemption strategy is each one of these agreements has something like that thing in italics. Each member country, which is GATT's country, each country shall ensure the conformity of its laws, regulations, and administrative procedures with its obligations as provided in the annex agreements. So all those agreements that filled in and took over the gap that have all these behind the border rules, every signatory country is told, you have to make sure your domestic laws meet that. And as a result, you suddenly have enforceable international law. Unlike, say, the International Labor Organization, it's a convention. There's no sanctions. There's no enforcement. You're supposed to do it. You sign up to do it. The environmental treaty, same thing. This has enforcement. And that is a big reason why various corporate interests over the years have wanted to hijack the trade agreements. So number one, negotiations happen behind closed doors. And in the old days, when it was about tariffs, it's because you were trading off one industry for another, and basically government would make a decision. Now you're writing all this domestic policy. And in the US, brace yourselves, there are 500 official corporate trade advisors, and 435 of them directly represent corporations and corporate lobbying organizations. You can go onto our website, rethinktrade.org. We have a feature called Loaded. We made an infographic about who actually is calling the shots. For the one that covers digital trade, Amazon has two. Does like someone like Yelp have one? Nope. Any of the not small, but smaller than the bigger guys are not represented. These rules are locked in. You can't change a comma unless every country who signed the agreement agrees. So you can have catastrophic problems like COVID and that WTO agreement on intellectual property events. There could be any quick generic medicines because every country has got this like, could be sanctions if you don't basically follow these boneheaded rules. So it locks in basically, especially in something like technology that's changing, it's not a very smart place to put rules of governance. By even enforceable, as I mentioned, the way it works is one country can say to the other country, hey, you're not meeting these rules. And then a tribunal of trade officials that basically have to work for the government or work for one of these agencies get to decide to impose trade sanctions. And you get, like, if you want to regulate privacy and it violates the rules, if these rules went into place, your export of grain could be sanctioned. So that basically you end up in your own government creating a lobbying crew of like, kill the regulation from whatever company or part of the government that is getting their actual exports, their trade sanction. And a trade sanction is just like a tariff you put up that basically penalizes the ability to sell stuff. But it can be hundreds of millions of dollars. The result is you basically can have global rules that are bad rolled out all in one. And so now we have this big conflict where you have Biden, you know, whoever thought you'd hear a president of the United States use the term big tech, much less in the State of the Union speech. That was a moment, that was like a mic drop moment of joy for me personally. And he's rolling out a new kind of trade policy, which is like excellent, except these Indo-Pacific Economic Framework Agreement negotiations are happening with the usual secrecy, with the usual corporate infestation. And as a result, we have them kind of heading off course relative to what the rest of the administration is saying, including with its all of government effort on competition policy. So IPEF is Indo-Pacific Economic Framework. It's 14 countries. It's going to have hundreds of pages of binding rules, and they're trying to finish it this year. And what the big tech platforms want to do is basically harness it to impose these bad rules. And the rules that they want to impose basically take away the tools, the policy tools that are needed to deal with the whole array of challenges. They don't literally say, like, you can't regulate privacy, but they say you can't regulate data flows. You can't limit where data is stored or processed. So they take the tools away. They don't say you can't regulate AI. They say guaranteeing new privacy. Governments are not allowed to see detailed descriptions of algorithms or look at any source code, which if you want to have a pre-screening, how the hell is that going to work? So the sort of punchline of all of this is this digital trade is a brand that came up with because it wasn't, really appealing to call it international preemption or no rules for big tech or whatever is a more accurate description. And just to make clear to everyone, this is not hypothetical. Literally in the last 3 months, the AI regulations of the EU, which are still not fully enacted, but as they're going through this process, ended up getting watered down when DG Trade, which is the directorate, it's like our US trade representative in the US, it's the part of the EU that's in charge of trade, came to the folks who were negotiating the AI rules and said, hey, we have a trade agreement with the UK, and we have to limit how much access the government has for oversight, for algorithms, et cetera. You can't have that much transparency. And so it got weakened right there. And by the way, on other issues, because right now the digital rules aren't in place, but on other issues, the US has rolled back lots of laws. You would be shocked to know Endangered Species Act rules, Clean Air Act regs, dolphin safety rules, et cetera. I recommend for anyone who wants to get into the details of this American Prospect story, big tech lobbies explain how they took over Washington, because it's actually a summary of a very good academic paper that interviews the people who actually hold the sides of making the digital trade brand. So here are the rules in sum, and this is where I'm going to start speeding through, and the people who want to actually see the language can see the language so that we can get into the discussion. But of the rules in the digital trade proposed chapter, the one that is the worst version of it of all time is the thing called the US-Mexico-Canada Agreement, the USMCA. That's the replacement of NAFTA that Donald Trump did. And for an administration that hated big tech, they certainly gave big tech a big presence. So one of the rules in there, and this is the model that the lobbyists, the industry lobbyists are trying to push into IPEF. They want to normalize it, not as like a fluky freak show, which is what that USMCA language is, but rather as a norm in the US policy. So number one, the secrecy guarantees I mentioned. It covers even detailed descriptions of algorithms, but also code. It basically conflicts with most of, and again, I'm learning this all from you all and Sarah and others, but everything that I have read that are the principles, the tools you need for AI oversight would be largely undermined. There is a set of rules limiting what governments can do relating to data and where it can go. And then there is a standard called the non-discriminatory effect, the non-discrimination standard, which I have called the anti-antitrust rule, which is to say it's a rule that basically does not allow you to regulate focusing on the size of a company, if that could inadvertently mean that a large foreign firm has a bigger impact from a regulation than a small local firm. Well, given there are a handful of really big firms, and unless you're in the US or in China, they are foreign. Inevitably, if you're a country that is not the US or China trying to do this, you are going to have a foreign firm have a bigger impact. So I recommend 2 studies for folks who want to read into the details of this and see it unpacked and see the citations and the side-by-side of the language. We literally took the language and then we took apart the main laws that were proposed in the previous Congress and the AI Bill of Rights language, and we did side-by-side. So you could literally see, here's the language that's being proposed, here's the thing that gets shish kebab. And you can find that again at rethinktrade.org. And all of this USMCA Article 1916 stuff you don't have to know in detail, but again, some of this is so alarming. I put this stuff in there so everyone who here is a scientist can go look and see I am not making this up. It really is that bad. Another study, again, to show that it's real, there is an annual report that the Trade Representative's Office does. It's called the National Trade Estimates. And industry is offered the opportunity to say what they think are trade. So we went through all their filings and we basically have the list of what the big guys are saying are the things that they think other countries have to be killed for being a violation of the discrimination rule or whatever. So also, again, fear not, actually, this is like a decision tree. This is like the things that I've learned to do from scientists. It is basically what the law is, the industry demand for what that article is, the US proposals in blue, the categories. The law is next, and then in gold are the mechanisms. And we went, here's the actual language. We went through all of these, this is the source code secrecy. And we did this for each of the key issues. So for data flows, again, ADPPA, my body, my data, the Fourth Amendment's Not for Sale Act, all that stuff. And here's the actual language that shows the problems. There is an exception in some of this language, and I just want to say one trade law wonky thing. If someone tells you there is an exception that fixes it, you will be warned that the exception that is in all these trade agreements is set up in a way that's self-canceling. And there is a ton of jurisprudence, and I actually put the link here, if you want the slides, to the paper where we have unpacked all the cases that show that in only 2 of 48 attempts in the history of GATT and WTO IE since World War II, that has ever successfully been used, which is to say, not an exception you want to rely on. And then this is the non-discrimination issue, and I threw in the European and other attacks here because it's been as much an attack on other countries. DSA, DMA, the amazing Korea App Store bill, that's like the basis of Blumenthal's US Senate proposal, the German GWB, Digitalization Act, like all of these things are listed on these target lists, but then on the yellow column is the US copycat policies that are trying to build off of these good ideas from other places. And I put the language side by side so you can see what the old language was and then what the crack USMCA language is. So here is the punchline, which is the good news is the discussion about technology and about economics in Washington under the Biden administration is super different than it was. And that is an opportunity, and we should not miss that opportunity. The trade representative just yesterday, Catherine Tai, gave a speech about how there needs to be a rebalancing of policy space and of representation, not just by the biggest platforms in what we do on digital policy. But we're up against a structure that has all those trade advisors, that has all that secrecy, that has a bunch of career negotiators who've done it the same old way. And so the dynamic's starting to play out a little bit where you have the government agencies that are supposed to be helping privacy and competition policy, like the Federal Trade Commission, the Department of Justice Antitrust Division, and the legislators like Senators Warren and Blumenthal and others who are doing the privacy legislation, the Oversight, and anti-online discrimination. They're starting to stand up and say, we cannot have the IPEF lock in that USMCA language or we're going to lose all of our policy space because it doesn't just apply in the other countries. It would become binding on the US. So a country like Singapore, which is in this IPEF, where the US has an enforcement mechanism with Singapore called investor state dispute settlement, not only could Singapore come after us, but all of the companies incorporated in Singapore could practically enforce the agreement against us through the investor state dispute settlement system that already exists and trying to get taxpayer compensation. The tricky things are big tech has a ton of money and lobbyists. And so a lot of what the work is now is to basically get their own words and show what they're actually saying, because otherwise we end up losing in fights because they have more people per square inch to cover the policymakers. And then there's a big keenness not to have Congress do a vote, which undermines leverage for oversight. Here's what you can do. Spread the word. If this presentation made sense, if you think this is important with your colleagues who are in the tech world, who don't realize that there is a Trojan horse sneak attack underway in the field where they are focusing their lives and careers, please make sure folks are made aware. This is what we call the Dracula strategy of killing bad trade policies. You must drag it into the sunshine. And right now, this is in the dark. Most people whose lives are going to be affected don't realize. And then a lot of folks have been writing group letters. There could be, if you are someone who's an academic, there has not yet been a letter of computer scientists who are worried about this. But there have been civil rights groups, there have been privacy groups, consumer groups, unions. So for instance, whatever is a niche that you may have, see me, Al Wallach, at Rethink Trade. We can help make sure that you get the letter to the right people, but also help you figure out how to shape it. We can make a big impact. And peer letters of groups of people actually are important. It shows people are paying attention. We can get a different model in this process if we fight very hard to counter big tech's agenda. And then we could actually make progress in creating international rules that explicitly preserve the policy space that is needed as compared to making trade agreements tools to undermine regulation and oversight, not just of tech generally. So thank you, everyone. That is sort of the overview. And I'm going to turn it back over to Sarah or Ben. Ben is up. Version of my slide.
I do. No, I do. So,
Hi,
everybody. So my presentation will be a lot less probably things for you all. But I'm Ben Winters, Senior Counsel at the Electronic Privacy Information Center. So we focus on privacy and civil liberties, and I focus on policy. So what I hope to give you today, at least, is sort of a general preview of some of the AI policies at the federal level that might be attached during the sort of state camp that we are talking about today. So Lori touched on a few of them, how the TESPA and High Value Data Act, et cetera, would be sort of put in jeopardy by this. But beyond just that, there are content moderation bills, there are all sorts of bills that could really be affected by antitrust without the context of AI, et cetera. But I want to sort of go through it in some of the same framing that Lori just put out. So sort of focused on like the transparency stuff, the lack of the inability to put government limits on controls of user data, and this non-discrimination provision, which especially from the perspective of the US, where a lot of these big tech companies are that are data abusers, that seems like a particularly horrible one. And following the federal privacy bill and AI bill space for a while, it's already a mess. And layer on this trade thing, it's overwhelmingly stressful. But I want to give you through a little bit more detail on some of these bills. So in 2019, and reintroduced a little bit stronger in 2022, there was the Algorithmic Accountability Act by Wyden, Booker, Clark, and a few others. So that's a federal bill. And what that would basically require people to do, companies to do, is to submit impact assessments for the most part to the FTC. It would be a lot of disclosure concerning sort of the types of data that your systems are using, the logic of your system, and some of those impacts of the system. It's not as strong as it could be because, some of those things should be public, and this should come with some more, bright lines and prohibitions. But that is something that even just that baseline level of transparency, which we absolutely do not have in either the commercial context or the government context in the use of AI, would likely be stymied by one of these USMCA or other trade provisions. Next is APA, the American Data Privacy Protection Act. This got voted out almost unanimously out of committee in the House last year, but has not passed. It has not yet been introduced this year, but it's one of the more promising federal baseline privacy bills. Something that we have not, added at any time, but it's kind of one of the ones that has gotten closer. And in regards to AI, that privacy bill has section 207, which is titled Civil Rights and Algorithms, and that's pretty much where the meat of anything related to AI is. So basically, it prohibits the collection, processing, transferring, or using covered data, which is really just a fairly broad definition of covered data. So that gets at the lack of government limits on terms control of user data, and prohibits using that in a discriminatory manner on the basis of race, color, national origin, sex, or disability. And so there's a few exceptions there for testing, but for the most part, it gets that prohibition, and it does have additionally some transparency obligations. None of these bills really have an official source code part to it. That would just be like, yeah, you have to put everything out there. And so maybe that would be a little bit tough, but I think that companies have shown they will go to great lengths to fight any degree of transparency about the data they use types of systems they use in sort of broader context in their organization that they play. And then others, there's been a bunch, but just last week, Representative Cardenas out of California announced that there's going to be an upcoming bill, which we have not yet seen the text of, but that will focus on protecting creators and giving folks rights to fight sort of discrimination by algorithms, which again would likely lead to controls of data, which would again sort of be stymied by some of these provisions that Lori laid out for us. And then there's a few other sort of disclosure bills, most notably really recently that Representative Clark, proposed a bill saying that any sort of political messaging that's AI generated in any way, really disclose that to the voter, to the person. And similarly, the Deceptive Practices and Voter Intimidation Act, which was tried to pass in the HR 1 a few years ago, but has not, would also sort of get at that sort of misinformation through AI. And to get under that, there's an underlying degree of transparency required and underlying control of sort of personal data being used to create some of these tools. And so again, that's something that might be signed by here. And then sort of non-legislative, there's a lot going on. The FTC, the CFPB, and the EEOC are doing some of the most at agency level. But particularly there is a FTC rulemaking, very generally on commercial surveillance, data security, and that includes algorithms, AI, et cetera. So we're not sure what those rules might end up looking like, explicitly. But if we get any sort of the strong rules that we want to get out of that process, that is something again that might be signed by some of those rules. And Lori brought up some of the AI Bill of Rights stuff. There's also AI risk management framework put out by NIST a few months ago, maybe almost a year ago. And that has, similarly to the Bill of Rights, a lot of hyper-specific recommendation in regards to controlling the types of data you're collecting, being transparent about that, doing a lot of testing and disclosure. And there are a lot of agencies that don't necessarily have direct power, but have sort of shown that the Biden administration is continuing to have interest in this. And so that includes one that just sort of closed yesterday. The NTIA, National Communications Information Administration, is doing a report and study on AI accountability measures. So that includes audits, impact assessments, all that good stuff that I'm sure a lot of people are talking about here at this conference. And so that is also being included in state bills in Colorado and California that are going into effect this year. So we'll see how the degree of transparency and control that impact assessment provisions have, and if companies will try to use the digital trade rules as one tool in their quiver to sort of try to stymie them. And then last but not least, in terms of the Biden administration, showing this interest in this topic, is really clearly in the State of the Union, he said that they, strengthen privacy protections, ban targeted advertising for children, which is something they've absolutely not seen on that scale, and demand tech companies stop collecting personal data on children. And so obviously here at FTC, a lot of folks here would love for more people than just children to have privacy rights, but if that has sort of this political will and possibility, that shows a very exciting, fact, but something that would absolutely fall into some of these exceptions in trade agreements. So I will stop sort of droning on the specific regulatory and legislative language at you, but Ben Winters, and if you want to email me, it's winters@everytime. Thanks.
All right, and next up we have Jai Bukra, who's a fellow at the AI Now Institute.
Hi, can you hear me?
Yeah.
Okay, great. Yeah, thanks for having me on this panel, and it's been so nice to listen to the panelists before me. I wanted to speak more about the larger context of trade deals from a developing country perspective. Like Lori mentioned, IPEF is not technically a trade deal, so the US Congress does not have to clear it. And this shows us that right at the outset, there is very little that is democratic about this trade deal in particular. Even in the US, it's usually not democratic for countries outside the US. And even though it's not technically a trade deal, it behaves like trade deals behave nowadays, which is that it seeks integration of participating countries into a particular supply chain and seeks to lock them into that supply chain. I think while that sounds a little bit irrelevant for technology, you have to understand that technological standards are now standards for the entire economy. And so if you're locked into a certain kind of technological standard, if there's things you cannot do with your technological companies, for instance, if you cannot deny them market access, or you cannot even tax them in the way that you want to, or you cannot institute, for instance, source code examinations, you're actually essentially losing out on digital sovereignty and sovereignty in general because of how the digital is linked to the economic. And we know that there's no actual sovereignty without economic sovereignty. So I think a lot of developing countries have been looking at these trade agreements with a sovereignty perspective, especially a technological sovereignty perspective. Unfortunately, it is the case that a lot of them, for various reasons, do not have the negotiating power to not agree to some of these provisions. But I want to talk about how AI regulation is affected from a developing country perspective due to these trade deals. I think the most important point here is that the primary AI companies that really matter for regulation, it appears, are going to be US companies. China, in my view, was the only real contender to this position, but export controls have taken care of that, at least for some time. And I think it's interesting because export controls do technically violate certain WTO provisions, and you've seen China actually challenge the export controls at the WTO based on this. But this is the case now, for better or for worse. It's US companies that dominate the AI landscape. And this inevitably means economic dependence for other countries because of how much AI is integrated, is viewed to be integrated into the economy. So even beyond the very important issues of anti-discrimination and so on, I think that the issues of economic integration are the ones that worry developing countries the most, including the provisions on digital services tax that in the IPEF that constrain the ability of developing countries to tax digital companies. But even more importantly, I think that regulation in tech has often flowed from other countries into the US. So whether it's data protection from the EU, which it's not like the US has instituted GDPR-like laws, but a lot of the world is now protected by those laws because the EU instituted it and not the US. But even regulations from China, such as algorithmic accountability and laws relating to children's privacy rights, trade deals foreclose all of this, not just by stymieing regulation in the US, but also stymieing it everywhere else. And I think recognizing all of this, developing countries have tried their best to negotiate against these provisions. They, of course, have a rich history of resistance against GATT, the WTO. There's been so much coalition building. There have been so many alternatives that have been provided. We know that for all its faults, the Doha Development Agenda at the WTO has still not been accepted by developed countries. So to some extent, there is a continuation of this resistance because there is an objective need for it, which is felt very strongly, despite very different political circumstances today than were in the days of the Doha Development Agenda. And you can see evidence of this from India refusing to join the Regional Comprehensive Economic Partnership, and also India deciding to stay out of the trade pillar of the IPEF. And from what I understand, the digital trade provisions in the trade pillar of the IPF played a large role in India's decision. I mean, I don't know if this decision is itself set in stone, but this is what drove it. Especially India seems to be giving up some of these positions in other free trade agreements. So it's complicated. But even countries that are already inside the trade pillar and negotiating have been resisting the digital trade provisions of the trade pillar, including large and important countries in this domain like Indonesia. So there is a groundswell of resistance against these provisions. And now, after all these years, it I think is becoming more and more evident that even the US has possibly shot itself in the foot on these trade deals, because the onerous requirements like regulatory impact assessments and all of these other requirements, such as the ones on source codes, etc., affect US citizens' rights as well and constrain the US government as well. So I think with AI, we will be in a situation where neither the US nor other countries will be able to regulate it, because we've stumbled through with this old regime of using tech industry wish lists and turning them into regulation through trade deals. And there is not one entity that benefits from this, except the most unscrupulous amongst the tech industry. So I'm really glad that this panel has taken place, and I hope that something very positive comes out of it. Thank you.
Thank you. Next, we have Patrick Woodall from the AFL-CIO Technology Institute.
Good morning. It's great to be here today. I'm Patrick Woodall. I'm the Research and Policy Director at the AFL-CIO Technology Institute. We focus on how emerging technologies are reshaping work and impacting workers, and that includes digital trade. A digital trade discussion frequently sounds like it has no grounding in the physical world. These rules cover any good or service that's delivered over the internet, so it's a lot of stuff. It's e-commerce, but not the goods shipped by e-commerce. It's the delivery of electronic goods like downloaded movies and music. It's digital services like email and smartphone apps and social media that people use every day. And it's cloud computing and big data used by companies, big tech firms, and employers. But big tech pretends that it's just stuff like Candy Crush, so it doesn't affect workers. But the big data and software in the workplace is impacting millions of workers, whether they know it or not. Trade rules constrain how governments can address the known and emerging harms of the digital economy, including the millions of workers harmed by bossware and big data. It includes back office, call center, and other workers whose jobs are digitally offshored. It includes workers whose jobs are controlled or managed by software, including retail and restaurant scheduling apps. It's workers like teachers that are rated or even fired by algorithmic management. It's warehouse and delivery workers that are prodded to work faster by productivity apps, and low-paid gig workers that toil for platform companies. And it's workers everywhere that are monitored on and off the job by their employers. These workers are all impacted by digitization, and the digital trade rules give all the power and the rights to the companies that control these technologies and data. Look, as Lori said, all trade provisions prioritize corporate rights over protecting workers, consumers, and the environment. But the digital authorities are more absolutist, and the limitations on regulatory governance are more stringent. Almost all domestic regulations that have been challenged under global trade rules have been declared illegal trade barriers. Even the threat of trade challenge can discourage countries from implementing common sense protections. But the prior trade areas like workplace and food safety were built on decades of regulatory scaffolding that at least theoretically recognize the value of those safeguards, even if not in practice. The digital economy, on the other hand, is almost totally unregulated. Governments, including the United States, are only beginning to confront the known and emerging hazards of these ubiquitous technologies. Congress is just starting to address digital privacy, workplace surveillance, and digital monopolies. And regulators are struggling to enforce the current law, including labor law, in a digital environment. The existing digital trade language grants broad powers to big tech and employers over data and software and narrowly restricts government oversight of the digital economy. That includes weak voluntary self-regulation for workers and consumers on things like privacy and spam and cybersecurity. But it really just reads like a list of big tech commandments. Thou shalt not restrict cross-border data flows. Thou shalt not require data to be held domestically. Thou shalt not access or regulate the software. These limitations lock in the current unregulated environment and make it hard to confront the downsides of the digital economy. The tech companies pretend that the data and localization provisions promote internet freedom and stand up to authoritarian governments, but it's really about offshoring. A 2021 Facebook study highlighted the offshoring benefits as a key rationale for the data provisions. Moving the data means moving any digitally enabled jobs, including data processing, call centers, back office, telemedicine, and more. Tens of thousands of US unionized call center and data processing jobs have already been offshored to digital sweatshops with pittance wages and non-existent worker protections. And important public data services like veterans' health records have been privatized. Policies to safeguard sensitive data or secure critical sectors could protect consumers, the economy, and US jobs, but would be illegal digital trade barriers. And these jobs are often offshored to countries with weak labor laws and histories of labor abuses. Look, much of the digital offshoring is already going to IPEF countries with appalling records of labor abuses. The International Trade Union Confederation counts 7 IPEF members as amongst the most hostile to workers and labor rights. Malaysia, Thailand, and Vietnam have significant forced labor and human trafficking problems, and child labor is persistent in India and Indonesia. Thailand, Korea, and the Philippines have arrested union leaders, and there are extrajudicial killings of labor activists in the Philippines. India and Philippines are also already home to thousands of digitally offshored back office and call center workers. And these two countries are also the host to an army of exploited ghost workers. These are the people that transcribe your Siri conversations and tag and code and enter data that is the backbone of artificial intelligence. The digital trade deals make it easier to offshore workers and harder to protect them from labor abuses. Employers use bossware to hire, rate, monitor, control, and even fire workers. These algorithmic management tools are secret and unaccountable black box systems that have real impacts on workers. Digital trade rules limit government oversight of bossware tools that can make it harder to enforce labor law. The USMCA and the US-Japan rules guarantee that companies can keep their software secret and prevent governments from accessing or evaluating the source code or algorithm blueprints for how this software operates. They allow specific investigations, but the specificity creates a hurdle to initiating enforcement efforts. To know what to investigate, you may need to access the technology. And it also basically prevents any industry-wide evaluations. These deals don't include exemptions for critical infrastructure, commercial contracts, or require companies to modify software to comply with domestic laws, amongst other things that could be massively improved. Look, this source code is the root of the bossware that harms workers. Workers are being monitored and managed by artificial intelligence that undermines their rights. 90% of the algorithmic management studies found that workers were harmed through increased de-skilling, job intensity, and job insecurity. Employers use these tools to screen job applicants, control, rate, and fire workers. Many employers evaluate workers' performance in real time and ramp up workload targets. Amazon warehouse workers and UPS drivers have their time on task constantly monitored, and workloads are regularly adjusted upwards. And many employers monitor workers on and off the clock. Big tech companies want digital trade provisions to take a hands-off approach to regulating artificial intelligence. The existing digital trade language makes it harder to oversee bossware tools and enforce the current labor law. Look, there's just-in-time scheduling software that encourages managers to press workers to skip breaks or work off the clock, which is like essentially wage theft, violating wage and hour laws. Productivity apps ratchet up work speed, and that leads to higher workplace injuries. Amazon warehouse workers are rated on their pick rate, and that rating is associated with serious injury rates that are 5 times higher than the national warehouse average. Digital monitoring has included snooping on a worker's social media accounts to sniff out union sympathies that can lead to anti-union coercion and retaliation. And automated job applicant screening has been rife with discrimination that makes it harder for people of color, women, older people, and people with disabilities to secure jobs. And gig workers are totally at the mercy of secret algorithms. The platform apps use algorithms to assign tasks, set surge pricing pay rates, and rate workers that affect income and job quality. Ride-hail drivers have challenged these ratings as arbitrary or racially biased, but the systems are totally unaccountable. These drivers can be disciplined through deactivation for not accepting tasks fast enough, declining ratings, diverging from assigned routes, or other mysterious reasons. Any effort to regulate gig work companies could get hung up by digital trade rules that protect source codes and algorithms. Look, employers are monitoring workers every day, every second, with all kinds of crazy technology, and there are effectively no protections for workers from workplace surveillance. Delivery vehicles put cameras on drivers and sensors that detect drop-off time, location, movement, and more. Warehouse and other employers monitor task performance and pick rate through handheld equipment. Employers use biometric monitoring, fingerprint scans, gait recognition, and facial recognition, which with its demonstrated racial and gender biases. And companies monitor computer use, keystroke, mouse movement, and watching teleworkers through cameras, essentially spying on people's homes. This surveillance contributes to safety problems, undermines the right to form unions, suppresses freedom of speech and assembly, and erodes the right to privacy. But any effort to protect workers from this surveillance could be stymied by digital trade provisions. Look, the privacy protections that exist now are crazy weak, right? Every online purchase, internet search, smartphone tap is collected and commodified. The existing language explicitly includes the unlimited right to control and ship personal data across borders. The deals promote voluntary self-regulation and restrict digital privacy members to those that are necessary and proportionate. But necessary and proportionate for whom, right? Importantly, the language only protects the users of personal information, but the users of workplace surveillance are employers, not the workers that are being monitored. Big tech companies and their corporate allies want to enshrine the unfettered right to control data and workers in digital trade tools and lock in this deregulated Wild West that harms workers, consumers, and communities. Look, it's not a binary choice between China's Great Firewall and a totally unregulated technology sector. It's time for a strategic reset to create a worker-centered digital trade policy that would provide robust policy space to protect workers from the known and emerging risk of the digital economy. First, digital trade agreements must include strong enforceable labor mechanisms combined with an obligation to respect the International Labor Organization's Declaration on the Fundamental Principles and Rights at Work. Second, there needs to be exceptions to data localization to allow domestic requirements to keep vulnerable personal and critical economic sector data onshore. That'll curb the wave of digital offshoring, and it'll protect people and the economy. Third, governments must be able to oversee algorithms and source codes to enforce current labor and employment law and other laws, and companies should disclose the impact assessments of these bossware systems to ensure they're in compliance with those requirements. Fourth, technology companies have to eliminate labor abuses in their own operations and supply chains. That includes gig workers and the ghost workers that power their digital platforms. Fifth, it should include strong requirements that governments implement restrictions on cross-border data flows to protect digital privacy on and off the job. Finally, the protections from privacy eroding and coercive anti-union workplace surveillance and other emerging digital threats that affect workers. Look, there needs to be a new way forward on digital trade. The Congress and the public should decide the rules of the road for technology in the workplace and society. That just cannot be left up to big tech and international trade tribunals. I want to thank Arthur for putting this panel together. I'm super happy to be here, and I'm happy to answer any questions.
All right, well, that wraps up our panel. So let's turn it over to questions. And so I'll ask folks who are in the room to come to the microphone if you'd like to ask a question. If you are joining us over Zoom, you can put them into the Q&A. But just to kick things off, you know, we've seen a variety of different issue areas that sort of fall within the constellation of issues that folks at FACT are working on, things like, you know, privacy concerns, algorithmic accountability concerns, effects on workers, and the impact of worker surveillance. So across these different functional areas, I think one of the things that I'd love to talk through is, you know, what's next? What are the ways that folks who might be under this larger tent can plug in and address these issues? Maybe, yeah, like to. This is working. Whoever would like to answer.
Yeah. Hi, everybody. I'm Kate Kay. I work for World Privacy Forum. Some people might know me from my reporting days covering AI data. So I have a couple of questions. I guess the big one is, you know, as a reporter for many years covering legislation and regulatory stuff, I have to say a lot of this idea that trade policy or trade rules is going to preempt all the stuff that we are constantly worried about, right? Is this bill going to pass? What's in the bill? All that stuff. Well, if it's all moot, how does it actually happen? Practically speaking, how does a trade preemption actually, like, you know, preempt or limit or stop something that's in past legislation, for example? And then a second question that maybe I think anybody could address. I'm really interested in some of you guys talking more about data localization, because it seems like there's a lot of tension around that topic. You know, Patrick just talked about wanting to ensure that, well, I mean, I'd love to hear him talk a little bit more about it. It seems like there's a lot of concerns if you look at certain rules happening, say, in certain African countries when it comes to how they want more control over localizing data in a way that can somehow can actually create a lot of problems for people. And, you know, but there's also a desire to have free and open access to data, right? And not have that localization and not have the government control. And I don't know. So I'm trying to understand that a little bit more too. But maybe you guys can tell me how trade preemptions happen practically.
Maybe I'll take a shot at that with an example that actually is going to be near and dear to everyone, unless you're vegan. Or vegetarian. Do you remember the brief period about 7 or 8 years ago where every package of any kind of meat product in the grocery store had a label that said where the animal was born, raised, and slaughtered? And that language was what was called mandatory country of origin labeling. And Patrick, in a previous life, worked in a group that fought really hard to help get that done. Congress enacted it after 25 years of fighting with the big beef guys. It went into effect. It was not discriminatory, but Mexico and Canada, kind of on behalf of the U.S. Cattlemen's Association, challenged that law at the World Trade Organization, saying, hey, you didn't conform your laws. That law doesn't conform to the constraints on domestic policy in the WTO. So what they do is they literally, there's a dispute settlement system, they file a case. A tribunal of 3 trade officials gets picked. There is not like great conflict of interest rules, etc. There's a lot of secrecy. And these 3 tribunals get to decide if the domestic law does or does not meet the trade agreement obligation. In this instance, they said, no, it doesn't. And actually, interestingly, it was a little bit like that non-discrimination rule I was talking about, where it wasn't that it was facially discriminatory, but it could have been found, they said. It could possibly hurt Mexican and Canadian beef ranchers more than U.S. ranchers have to follow. So they ruled against it. There's some appeals. There's a lot of howling and jumping up and down. The U.S. tries to change the law to conform. They lose that. In the end, almost $2 billion of trade sanctions against U.S. exports were authorized by that tribunal if the U.S. didn't kill the law. And so the Obama administration first issued a regulation weakening it. And when the WTO said it wasn't weak enough, they actually put into a rider and an appropriations bill and must pass piece of legislation. They gutted legislation that had been duly approved by Congress, by the way, has been all the way up to the Supreme Court in challenges by the cavalry, and cert had been denied. The Federal Circuit had said, no, it's totally fine. This is a law that can go forward. WTO said that with the threat of $2 billion a year of sanctions, tariffs, fines on our exports, it gets killed. Typically, it doesn't get that far. So the sad story is, and this is a power dynamic thing, a lot of developing countries just get it challenged. And the thought of the years and years of legal fees, and government fighting, and the potential threat of the U.S. cutting off aid or whatever else the EU or the U.S. can do, a lot of countries just drop their law. But the U.S. has gotten rid of the Marine Mammal Protection Act dolphin safety rules that used to make sure like the dolphin safe label meant flipper didn't die. Don't need flippers not in the can now. It means flipper could have been drowned in a net, but that's still okay now. The Endangered Species Act rules like sea turtles, there's a whole set of laws. So that's how it works. Sadly, very effectively.
I have another question for Lori. I'm Sandy, I'm a master's student. I was wondering, is there another source of a solution when it comes to like renegotiating policy, like you were talking about USMCA and that, I assume they do get renegotiated, whether or not there are often changes in that manner?
That's a really good question. I think probably Patrick might want to weigh in on that one too, because he's been watching the trade stuff since the 90s with NAFTA. The answer is they very infrequently are renegotiated. So the USMCA, the NAFTA renegotiation is sort of like a unicorn trade world. They typically don't get changed, just new stuff gets added onto the agreements. And one thing just to flag for everybody, the Indo-Pacific Economic Framework, IPEF itself, is a big honking deal because it would cover 40% of the global economy with whatever rules it hatches. However, the reason that the industry guys are so focused on it is they're trying to make that the US position to take to the World Trade Organization, which instead of changing old rules that are problematic, like the ones that have sacked Trump's previous laws, and like India's constitutional rule about no tax in the flight forms to seas. There's a whole list of horrible things the WTO is ruled against. Instead of fixing that, there's a push to put digital trade rules in the WTO now. So the tech guys, the lobbyists, are trying to get the US position through IPEF, the corporate position. They can then take that to WTO. It's very rare that gets fixed. But the question you might be thinking about is, if it's already in USMCA, why isn't the US totally stopped already? And it's because it requires a country to want to enforce it against you, or a company, if there's the private investment enforcement. And so with respect to the US, Mexico, and Canada, the US has been running around US companies threatening Canada's media marketing code as a violation of the USMCA rules that have to do with discrimination. So the last thing Canada's going to be doing is chucking any rocks, given they're in a glass house. Mexico actually has better privacy rules than the US does for data. And so various companies are saying, oh, you can't do that in Mexico. So right now, it's like a standoff where there's bad language on paper, but no one's interested in enforcing it. If you got into the IPEF, much less the WTO, we'd have a lot of actual enforceable kind of action.
Hi, my name is Marissa. I'm a data scientist at the AFL-CIO. Thank you so much for the session. This is extremely interesting, and I feel like I've heard so little about this topic, but it's so pertinent. One question I have is whether, my understanding is these negotiations are generally secret. Are there any prospects that they might become more transparent in the future? And what do you think about that? And then the second question is, I know you mentioned civil society has been speaking up about this, but technologists generally haven't. What do you think technologists should be saying, and where, what outlets should that be said in?
So you're right that these negotiations have been largely unfolding in secret. And one of the points on which I think civil society actors have been weighing in is to say that we need greater transparency around the way that the negotiations proceed, so we even know what's on the table. So think that's an item to continue advocating for. And on the question of, weighing in, so we've seen a number of different sort of like clusters of groups that have written open letters on this front. These are often like policy or civil society organizations. I think it would be really excellent to see more technologists talk about the impact of these trade negotiations on their work. And so, like Lori said, if folks would be interested in gathering together to write a letter or something along those lines, it would be a significant contribution to this space. I think particularly given the secrecy, the limitations on who's able to be in the room, even just showing up to say like this is an issue that impacts folks in wider society can have a significant effect, saying that like actually we are paying attention to these issues. And I'll just say for the members of the panel who are on Zoom, just unmute yourselves and jump in if there's any issues that you want to weigh in on. Thomas.
I was just going to add one other thing, which is on the secrecy, it's a real catch-22 because it seems too crazy to be true. And typically when bad trade agreements have been sunk in the past, it's when they are liberated. They're not voluntarily released. They are liberated and posted, and everyone gets to see them and looks at it and says, holy beans, it really is that bad. So the transparency issue is a huge problem, and it's one that has been an ongoing problem. And if folks are interested in communicating concerns about the practical rules, I think it's also really impactful to say, basically, these are not the nuclear codes. This is writing about what the rules will be going forward in our lives. Therefore, please make this public. Reiterating that from more people helps denormalize what, like as a recovering trade attorney, every now and then I'm like, well, it's all a secret. I mean, I fight against that. But if you're trained in that world, like that's the norm. And having people from the outside say, yo, peeps, that is not normal. That is not okay. I think that's a really important message. And I don't know, Patrick, dive in, please.
Yeah, I do want to answer the question about data localization. And so look, there's a distinction. There are two sorts of things that are often conflated. One is a sort of domestic presence requirement, or whether the data servers are going to be domestic. And the other question is whether the data itself, whether some categories of data are so important that they might warrant domestic protection. There are already some things like this, right? Financial data is domestic under USMCA because Treasury and the SEC want to actually enforce tax law on it. And they don't want people to be able to run their financial data to some data haven where they can't actually enforce the tax law. So the question is really, are there some things like your medical records that you think would be safer held here than in internet? And remember, all of these data questions, they're phrased as if there's some sort of magical free flow of data that is inherently liberating, but it's mostly liberating for the companies. And all of the data is everywhere today, right? So this data is crossing borders today. And if you make any restriction, like protecting kids or doing something with privacy, it inherently restricts the flow of data across borders. They phrase it as a free flow of data question, but really, if you're protecting the privacy, confidentiality, or security of any piece of data, that is inherently a barrier to cross-border data flow. And that is why Facebook is freaked out about it. That's why all the companies are freaked out about it, because they know that if we establish protections for the data itself, for personal information, medical information, financial information, for whether or not our water systems, our data is held domestically, or the power grid is held domestically to increase cybersecurity, any of those protections would be violations of localization and cross-border data flow. And they frame it in this sort of gauzy, ethereal internet data freedom thing. But the reality is they just don't want to, they don't care about protecting your data because they're making a lot of money on it.
Thank you, Patrick.
Thanks a lot. I'm Tom Schreins. I teach at Emory School of Law, and I've worked in digital trade for years, but I would have never imagined to have a panel on digital trade. And in fact, thanks a lot for bringing this topic to the this venue and to have this discussion. So I have two related questions that are about the intersecting communities that are engaged in this kind of discourse. And I'm a scholar, and I can't help but think that there's such a disconnect between the scholarship on digital trade and the take that you've presented to this audience. Because if I go to a digital trade law conference staged by my colleagues and friends in digital trade law scholarship, most speakers there will be in favor of digital trade. They will write papers that think it's a good idea to have the WTO or the USMCA or EU trade agreement address these important issues because we want international coordination or we want free data flows. And I don't think they're all captured by industry. So maybe we want some of these rules to be drafted in international venues, but the question becomes what kind of. So I was wondering if you had opinions on the interplay between the scholarly discourse on digital trade and your positioning against these digital trade rules. And I think what Patrick was just talking about is such a good example for that free flow of data issues. That's something that we should support through digital trade rules because it's for internet freedom, or is this something we should oppose because it restricts state stability, restricts data flows in the interest of sensitive data or privacy? And the other related question is how to bring all the expertise and knowledge that this community has, not just into the digital trade scholarship, but also into the digital trade negotiating practice. Because the example that you highlighted about the source code protection is, I think, a case where the trade negotiators weren't fully aware of what they were doing. They were pushed towards stronger protection for source code by industry that has an interest in not being forced to disclose source code for competition reasons. And they didn't really think about the implications that would have for their accountability work that many of us here are interested in. So the question is, how do we get these concerns around accountability earlier onto the radar of trade negotiators? Thanks a lot.
There was also a question that came through the chat earlier that was, where did the iPad originate? And maybe having some of that context would also be useful for Tom's question.
Right. So IPEF originated from the National Security Council. And the idea was to get a gathering of non-China group countries in the Pacific Rim as a group to try and make some common rules. It has 4 pillars. The trade pillar is pillar 1, is just part of it. The other parts are much less detailed. Pillar 1, I feel it's gotten kind of out of control. So they just finished pillar 2, the whole thing's 17 pages. Pillar 1 now has 10 chapters, each of which the digital one is, dozens of pages. And it's getting, as Jay said, it's like a very detailed trade agreement, minus some really bad things that are being left out, God bless the Biden administration. So there's a bunch of horrible stuff that's been in past bad trade agreements are not being included. But this digital stuff is tricky, and I think there isn't a balance. And to sort of go to Thomas's question, I think one of the biggest problems is there is enormous capture within the negotiating world. And there was recently a really scathing report that Senator Warren put out that was based on Freedom of Information Act, information communications, because tons of former, tons of former U.S. trade representative staff have gone out of USTR and are now working for Meta, Google, Amazon, etc. Literally, like the entire executive wing of USTR of like 2 or 3 generations have revolving doored out into big tech. And so there's some people who revolving door back in. And so you have, when people bring up the kinds of issues that we're discussing here that people in fact are concerned about, the first thing that you get is a, here's the door, talk to the hand from the career people. Now, the thing that's great is the leadership, the political leadership, USTR Catherine Tai, realizes that there has to be a different balance. And I think she wants the policies to be consistent. But the negotiating hierarchy of all the people who've done it one particular way is very ingrained, not just the trade representative's office, but in other places. So you've got a situation where you have industry being these private advisory roles. You've got people who are going in and out of industry and the trade negotiating, and you end up with some very rigged rules. So I think part of the difference in the discourse is, if you listen to, for instance, what Patrick and I were saying, we were saying we need different rules. So the kind of things we think it's safe to have rules on are the things that aren't these areas of subjective policy. So like, what is a kosher online contract? What is an online signature that can be okay? There are some actual commercial questions that need to actually be agreed by countries. And those kind of questions are appropriate to have an international agreement. But, the way Patrick described it is, you shall not, putting down like commandments that just take away the entire area of potential policy tools in areas that are subjective, where there are differences between countries. Different countries may come down to different decisions about what the right balance is. The thing we don't want to see imposed is locking in a set of rules that really only favor and are useful for the largest platforms. So I wish there was a better discussion without seeming to be critical of the academic discourse. It would be an interesting discussion to talk about practically, the ways in which the current rules are now being used to threaten pieces of legislation that maybe some of the same professors would be supporting without realizing the conflict.
Hi, everyone. My name is Maya Wallach. I'm like a think tank over in New York that thinks a little bit about the sort of local city level work on regulation and oversight. And I just have a question about sort of how the local frameworks intersect with a lot of these national and state and certainly international ideas. And broadly, because I'm thinking about New York in particular, we have some significant efforts to do a range of anti-discrimination work, but strategies are also salient in a lot of localities are things like just sort of outright bans on technologies that may be dangerous for civil society. And so I'm just sort of curious where should this be a time to be successful, or where does that constrain localities to? Should we be thinking about, and just there's sort of what would be the strategy that would still be on the table in the event that something like this were to go through? And broadly, thank you for this conversation. It's incredibly energizing. It's awesome. Thank you.
Patrick? I don't want to just keep talking. Jay, anyone else?
Not on that question, but I did want to comment on an earlier question from Hillary and data localization, but maybe after Patrick has spoken.
Yeah, let's go back to that one.
Yeah.
Lori, I think you're the best person to answer these state, local, federal, sub-federal questions.
Okay, I'm just trying to pass the time. So the way it works legally is the agreement is binding all the way down to local unless exceptions are taken. And because the text hasn't been public, we haven't seen the scope language. So for instance, there's typically a clause that says something like, unless a country takes an exception, and you can sometimes schedule an exception in an annex, then this covers to this level. Since NAFTA and WTO, it's typically covered the whole way down to local. States are definitely covered. Typically, it's all the way down to local. Then what ends up happening is in US law, because that's the international law, in US law, the federal government has an obligation as the signatory sovereign to enforce the obligation that it has made to other signatory sovereigns with respect to its sub-federal entities. So there are a couple of very infamous WTO cases where ultimately the kind of wisdom is the federal government has to use every tool available, cutting off funding, preemptive lawsuits, et cetera, and use all of its tools. And if the point it has, it still can't make the state or locality change, then it's not liable. But absent basically beating the living stuffing out of the non-conforming state or city, it's the sanctions would apply. And so it's really enforceable. So the answer is, do not think about how to get around it. We must make sure the rules are giving us the space. Because again, you can have rules that cover a bunch of these things. You just have to have the flexibilities. You can even have rules on the data issue. Like there are many different flavors of these rules where it depends how good the exception is and what it covers. And if there's going to be an error on one side or the other, the question is, where is the error and whose favor? Is it in favor of policy space? Because you're never going to get it exactly right. So your exception might be a little bigger than maybe is the optimum of perfect balance, because there might be some bad stuff, 10% of bad stuff that is protectionist or is nefarious or whatever it is that ends up happening because of the way you make a big exception. But I'd much rather have a little bit of that than like a total wipeout of any control of data security or privacy. And so you'd have a rule like data flows, and then you'd have an exception that carves out policy space for the governments.
So we had a question in the chat that was for Jad, and I'd love to circle back to. It says, you had said that India refused to join the IPEF's trade pillar over concerns about U.S. digital proposals. Can you say more about what some of those concerns might be and why haven't other countries joined them?
Yeah, I posted the answer in the chat, but I realized that not everyone can see it probably. From what I know and can guess, one of these provisions is that the agreement requires that if the government shares government data with any domestic entities, it is required to share it also with foreign entities. And this obviously, you would have security concerns about this, but you would also have concerns in terms of economic competitiveness, because the government of a developing country like India can choose to preferentially share government data with Indian startups in order to encourage the development of an Indian tech industry that can potentially compete with, the tech industry of other countries. And this would be completely foreclosed in the agreement. There's the usual stuff about the source code examination restrictions, even e-sign standards, because they are perceived to make US law global law, and obviously free data flow requirements. I think on the free data flows and data localization, I think it definitely, like Patrick said, is a question of enforcement. And also a larger question of sovereignty. And when I say sovereignty, it doesn't just mean state power. It also means that I, as a citizen of India, have some say, however imperfect, in how the government governs data that is in India. But I have no say whatsoever on how data is governed in the United States or elsewhere by other governments. And so this is like a quite important question of sovereignty. It is also used as, from what I've seen, as a bargaining chip by developing data-rich countries in order to not just concede free data flows for nothing in return, because if you look at it, it is a very unfair arrangement, because data flows out of these countries and they don't actually get anything in return. So they're seeking to get some concessions in other parts of the trade deal in return. And this is why this has also been such a contentious issue. Thanks.
Hi, my name is Andrew. I'm a PhD student in computer science at NYU Center for Responsible AI. And I kind of had two questions, but I think they're kind of quick. The first one is a bit of a clarifying question. I'm having trouble understanding if national legislation supersedes what's in these trade agreements, and it might not be clear in my mind because it might not be clear how it actually works. I got a little bit more clarity from the previous question about local legislation, but if you could just touch a bit more on that, that would be great, just for understanding. And the second question is there any case studies, or is it worth thinking about at all, like sneak attack, reverse away from the fairness community to try and get better oversight and regulation through these types of trade agreements? I'm just curious about that.
Patrick, do you want to start? I'm just trying to make sure I'm not blah, blah, blah.
Everyone loves to hear you blah, 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 Laurie. I think on the first question, the sort of what Laurie presented initially was that all member countries have to comport their laws and regulations with the trade rules. So there is sort of there's those rules trump, the trade rules effectively trump domestic law at the federal, state, and local level, as Laurie just said. And I personally find the country of origin meat labeling thing super salient because I worked to pass it and then got kicked in the teeth when Congress knuckled under to Geneva. On your second question about the extent to which we can do a sneak attack to get good stuff in these trade agreements, I think there is effort right now. We and Laurie and others are working to see whether we can actually provide digital policy space to protect privacy, to give oversight to AI, to address and confront sort of digital monopolies. But this is a crazy heavy lift, and it's not really ever been done. There's nothing in any of the trade agreements that's really been protective of anyone's interests but the companies. So I think it's an idea where we've been working to do this, right? We got more labor protections in USMCA than were in NAFTA. There are efforts to do this, but it is an uphill struggle would be a supreme overestimation of the lift.
And I would just add to that. So practically, how it would work is, let's just say Senator Blumenthal's App Store bill that's in the Senate gets passed. That's basically just a really basic antitrust stuff. So that says any developer can use more than just the payment system of Google or Apple, which are a duopoly. You can have another system, and you can offer your creation on more than one platform. And this is very similar to what Korea passed. As Google and Apple basically, because there's so much control, can make you just use their payment system and then take a huge cut. And then also they can say you pick one of us, but you can't be on both, and then try to figure out. So this is a basic good anti-monopoly stuff. The way it would work is that would have a disparate impact depending on the size of the company and how much of the market the company had. And so a law like that would be out of conformity with the rules. Or, for instance, another one that personally makes me super nervous, and it gets to the question I was asked about local New York stuff, is the places where they're trying to regulate the online ride-sharing companies and try and make sure that the workers are paid like a taxi driver would be paid with some like basic, withholding, et cetera. And for that matter, in some countries, they want to put in hours of service so that it's basically the same kind of labor laws as apply to limousine drivers or bus drivers. And all of those kind of things, if it's like Uber is the biggest one in the market, and there are a couple of European ones, one from Spain that's huge in Latin America also. If it happens to be that the foreign one is the bigger one, even though the law may say everyone has to have these kind of rules for any kind of transportation company, whether online or brick and mortar, if you have more than 5 employees and here's what an employee means, this is what you have to do. That kind of law could run afoul of the antitrust rules, just for instance. And so then the country basically would face these threats after a challenge unless they dump the law. That's how it works. As far as the reverse sneak attack, like we're not sneaking, we're publicly saying we should do the right thing. So the sneak attack part is basically already the sneak part of the sneak attack's been a little foiled because a lot of members of Congress have suddenly come with big megaphones and flashlights and said, holy crap, who elected them to do this? We're writing stuff that's the opposite of this. And so it's getting out. But like really, I cannot tell you how important it is, even if you like tweet it, if you chat about it with a friend, the more people who know, the harder it is to get away with this. So the places where we've got terrible trade agreement rules rigged by industry, it's a race against time. We're in a race against time. Are they going to finish this Indo-Pacific Economic Framework, which they want to do by the end of this year, and lock in these rules? Or are we going to sunshine it and make it clear we can't have these bad rules in there. Or we either have, we take out the bad rules or we get better rules. Because of the USMCA rules, there are 5 particularly pernicious rules. 2 of them just have to go. There's no place for them. Like the secrecy algorithm, there is in the WTO already what are like trade secrets protections for undisclosed information. All countries have that. This is an extra special, doesn't help anyone but big tech thing that should just go. A couple of the other rules we have to rewrite to make sure the exceptions work, to make sure the balance is different. And so, can we pull it off? I think Patrick's right that, we're really up against it, but the more people who pile on and make sure people know about it, the less they're likely to, the industry guys will get away with the bad stuff, and the better chance we have to get the right rules.
Thank you. Super interesting panel.
So I think that wraps us up for today's panel. I just want to say, I see a lot of faces of folks who were at the policy panel yesterday. I think one of the things that really came out of that discussion was that there's a lot of regulatory momentum in support of the kind of work that folks are doing in this space. That AI accountability work is, really critical at this moment. And I think what this panel really nailed down is that, in addition to having these regulatory discussions about what the right way forward for accountability laws look like, we also need to be looking at what's happening at the international level and, prevent the subversion of, the work of this space through these trade negotiations. So really appreciate everyone on the panel for elucidating these really, kind of wonky and complex issues, and for everyone here who came to have the conversation. So,
and thank you to our chair.